It's just about 8 minutes after 7 o'clock as we are inside hour number 2 of the Breakfast Roundtable for today, Tuesday, terrific Tuesday, 26 January 2016. We're putting the spotlight on the recent Privy Council decision that the repeal of Section 34 was legal and justified. We've got some reaction and also some analysis to come our way from attorney at law and a member of the Police Service Commission, Martin George. Good morning to you, Martin George.
Hi, good morning to you, Jesse, and good morning,
Mr. George.
Good morning, Edison. Good morning, Dr. Wade.
CJ, good morning, sir. Your Honor.
Say that.
Okay. So, Martin, what I'm going to do, I'm going to refresh everyone's memory with respect to some of the major reactions that took place yesterday, as well as the announcement of the Privy Council dismissal of the appeals. Yes?
Yeah, sure.
Okay.
The 19-page judgment ends with one conclusion. These appeals will be dismissed. And it paves the way for Steve Ferguson and Amir Idu, who are accused of corruption associated with the Piarco Airport, to stand trial. Idu, Ferguson and Maritime Life appealed the decision to repeal Section 34, under which they would have benefited from a statutory limit of 10 years, meaning defendants with cases 10 years and older could appeal for them to be thrown out. But with Section 34 repealed, they could no longer benefit from the limit. They challenged the repeal on 5 grounds: that it was contrary to the separation of powers, it was specifically directed against the Piarco defendants who had made applications under Section 34, it violated their constitutional rights, it conflicted with the defendants' legitimate expectations, and it was an abuse of power by the DPP. In making its judgment, the Privy Council explored all 5 grounds. On the issue of separation of powers, it says the question was whether the repeal directly interfered with current criminal proceedings against the appellants in a matter consistent with the separation of powers. In the board's opinion, it did not. It also says the arguments based on legitimate expectation add nothing to the appellant's other arguments. On the matter of the DPP's involvement, the appellants argued that he was in breach of objectively functioning as a prosecutor when he sought an adjournment of the committal proceedings in 2012 without disclosing that he planned to use the time to promote a repeal of Section 34. But the Privy Council says there is no evidence that he had already resolved to promote a repeal of the section. So far, the record shows he did not raise the possibility of repeal with the AG until 3 days afterwards. Other businessmen accused in the Piarco Airport matter had also made applications under Section 34, but only Idu, Ferguson and Maritime challenged the repeal.
So that's more or less a summary of the Privy Council's judgment released yesterday, Martin George. Let's pick at that a little bit.
Yeah, sure. I'm listening.
Okay, so one of the things that everyone is asking is, what does this mean for the justice system, as it were? When we spoke with Herbert Volney yesterday, he said that Section 34 was meant to do some good and important work, and now that work still remains undone. People still continue to suffer on remand yard and so on and so forth. And we've just set back things several years by not having Section 34, even though he understood the necessity to repeal it in this instance.
Well, if one looks at the ruling of the Privy Council, they specifically addressed that point, and they said that there's no constitutional right to have a matter dealt with or dismissed without a trial. So while we may understand the objective, I think clearly the Privy Council is saying that, look, at any rate, your approach of doing it by way of Section 34 was wrong, because they were saying that there's no constitutional right that any citizen has to have your matter dismissed without the benefit of a hearing or a trial.
Mr. George, good morning.
Good morning.
There must have been very bitter disappointment for the appellants, seeing that when this was the appeal was in the House, there was unanimous decision as far as this is concerned, and before the appeal, the appeal came up in the House itself to repeal the legislation. They felt that that window of opportunity must have resonated with anybody who knows the law, especially the Privy Council, that they had a case. So there has been, as I'm saying, bitter disappointment that the Privy Council unanimously disagreed with them.
Yes, but one of the interesting things, Edison, coming out of this, as I indicated earlier in another forum, is the fact that notwithstanding the disappointment, we must all recognize that there is still in Trinidad and Tobago, I would say, fairly broad-based respect for the decisions of the Privy Council. So in other words, whether you like it, whether you dislike the judgment, whatever, there's still always that underlying and fundamental respect. And I'm saying that if we eventually switch from the Privy Council to the CCJ, I can only hope that same respect will be accorded to the CCJ, because, in Trinidad and Tobago, we always love to, have conspiracy theories, to say, well, maybe someone made a phone call or, someone was reached, as a result. So I think that regardless of what the result is, the most important aspect of this is that there is that broad-based acceptance of the finality and the impartiality of Privy Council rulings. And I think that is certainly a good takeaway from this judgment, and something we must bear in mind if we are at all to ever, replace the Privy Council ultimately with the Caribbean Court of Justice.
And in this context, do you think it's a shot in the arm for those who have always lobbied for the retention of the Privy Council?
I actually think it is, quite frankly. I think it is, because you ask yourself, and we can ask ourselves the question rhetorically, had this been a decision of the CCJ, would there still have been that level of respect for the decision?
Absolutely.
I hope so, but I don't know. I can't say for sure that there would have been, because you may have had persons, muttering and, grumbling and wondering, and, of course, then you'll start to see on social media things appearing with people, making suggestions. So I think we have to understand the importance of the role that the Privy Council has played historically in the life of Trinidad and Tobago. Remember, as far back as the 1934 case of Ambad versus the Attorney General, you had the Privy Council ruling, and that's where they came up with the phrase saying justice must not be a cloistered virtue. So we've always had that rich history of acceptance of the rulings of the Privy Council, and we must ensure that if we do make that transition to the CCJ as our final appellate court, that same level of respect is transferred. Otherwise, we are going to run into problems where people don't trust the decisions of your final court.
That said, we will be in a bit of a sticky wicket because the Privy Council would like us to grow up and move on from them.
Oh, yes, certainly they would like that. They would like that. But, it's like, a child where the parents are saying, it's time for you to move out of the home.
Get you an apartment.
Yep.
But Mr. George, the impact of justice delayed, is justice denied. People who have their cases 10 years or more still waiting, some of these people who are in remand and so on, as we heard yesterday from Mr. Volney, the charges that might emanate from the case when they go to court, they might have already been, the sentence or the judgment, they would have already spent probably that time incarcerated. How do you treat with that?
Well, this is the point, and there's no excuse for our judicial system being so slow and unwieldy and cumbersome and unmanageable. And let's look at the example of the Privy Council. These matters would have contained thousands and thousands of pages of documents, arguments, submissions, cases, authorities. Yet still they were able to cut through the chase, get to the issues, make a decision, and deliver a ruling in a 19-page judgment. So in other words, they haven't spent time doing an 88 or a 100-page judgment. In 19 simple pages, they have analyzed, assessed everything, and that's what we can learn from this, because they don't know who the appellants are. They don't know who Mr. Ferguson is, or Mr. Galbaransing, or Maritime Financial, and they don't care. They are simply getting to the legal issues, deal with them, deliver a judgment, and move on. We can learn a lot from them in the way they handled this matter, because you are looking at particularly these cases where they've been hanging around in the magistrates' courts for more than 10 years and cannot be completed. The preliminary inquiry. Listen to the name, preliminary.
Yes.
This is your preliminary inquiry, and it's going on for more than 10 years and cannot be completed. That's an indictment against the judicial system in Trinidad and Tobago.
And no one seems to be embarrassed enough to want to do something to change that.
This is the point. This is the point.
No shame, no shame.
The Privy Council in England can deal with our matters faster than we are able to deal with them ourselves. And, so again, it does not augur well for our administration of justice for these things to be occurring. Granted, and just to follow up on the point that was being made about, delay and justice delayed being justice denied. In these particular instances, I think most of the delays are self-inflicted in the sense that you've had several applications filed along the way and, several motions and applications for judicial review. So therefore, if you yourself are filing these applications and your matter is delayed, then certainly you cannot thereafter complain about delay, But I think in the situations of persons who are sitting in custody, in remand, and their matters through no fault of their own are being delayed, then I think you really have an issue that must be looked at.
Now, the PP government was flogged mercilessly, Mr. George, during that imbroglio. Do you think this is any kind of salvation at all for the previous government, and now a shot in the arm for the UNC?
And before you respond, Martin George, I just want to play the comment from opposition leader, former Prime Minister Kamla Persad-Bissessar, who says that she feels extremely vindicated by the result.
And to get some immediate reaction to that ruling, today we're now joined on the line by opposition leader Kamla Persad-Bissessar. Good evening to you, Mrs. Persad-Bissessar.
Good evening, Kamal. Good evening, Golda, and to your listeners and viewers out there. Good evening to you all.
Thank you. Just to respond immediately to some of the statements made by the Attorney General, he's saying that paragraph 3 in that judgment basically exonerates the then opposition because it places the responsibility for the proclamation of that clause on Cabinet and not necessarily the entire Parliament. Just your response to that, please.
Well, first of all, let's remember that the piece of legislation which brought into force the Section 34 was legislation that was passed with the votes of both the opposition and the then government. I think what we should want to pay more attention to and not revert back to this blame game, it was clear that the entire Parliament passed the legislation. And what this has done, it is really a vindication of the rule of law and, of course, of the Constitution of Trinidad and Tobago with respect to the law-making powers of the Parliament. And that is to say, in the judgment, the Privy Council did indicate that the amending bill was to correct an oversight, and that is how it was dealt with here. But I see, with respect, as I say, to the rule of law and the Constitution and to due process, I think this judgment is a resounding victory for the then government, the partnership government. There was much vindication, much political attacks with respect to it. Legislation that was passed, as I say, with the approval of both the opposition and the government. So we can put this specific matter to rest. I think what I heard the President Attorney General saying a few seconds ago, the question now is that this clears the way for due process to take place with respect to the criminal justice trials dealing with these persons. This judgment also removes about 42 persons who may have filed applications trying to take advantage of the benefits that would have accrued from that infamous Section 34.
Mrs.
And so the way is now clear for their trials to proceed.
Thank you very much. We do not have very much time, but thank you very much for giving your response to that. We know you issued a statement earlier.
Okay, so you would have heard what she had to say, Martin George. Your response and your thoughts on her comments.
Well, the thing is, Jessime, I have always indicated, and I do so very respectfully, that I can never understand or fathom the minds of politicians, particularly in Trinidad and Tobago. And it certainly boggles the mind as far as I see it that, we have our politicians on both sides of the aisle now rushing to, shower themselves with champagne and, backpacks and, praising each other and, saying that, they did such a good job and they feel vindicated when they are all the ones who created this imbroglio in the first place.
Mm-hmm.
So, you create a conundrum, you then have to go back and resolve it and fix it, and now you are praising yourself for fixing the very problem that you created in the first place. I guess maybe I am not, at that level where I can comprehend that as a praise or a vindication. I just absolutely refuse to see it as such. The point is, it ought not to have taken place from the get-go, and both sides of the House are responsible because they were all there, they all sat on it, they all voted on it, and then they all then had to go back and fix it. So to tell the public that you feel vindicated, I don't think either side respectfully has any right to come out and say they feel vindicated.
Let's just hear very quickly from the Attorney General, because they did reference his press conference, and I want to refresh everyone's memory with regard to what he said yesterday.
Attorney General Faris Al-Rawi is describing the Privy Council's judgment as a victory for the people, especially for those outraged by the early proclamation of Section 34. Now, the AG says that the judgment also points to who was responsible for the controversial piece of legislation. According to AG Al-Rawi, paragraph 3 completely exonerates the then opposition, now government, in the passing of Section 34.
That puts to an end the position which we had heard by the last government, now in opposition, repeated up to very recently, that the whole Parliament passed Section 34. It is conclusively clear now that it was the Cabinet of Trinidad and Tobago, under Prime Minister Kamla Persad Bissessar, that had the sole responsibility for proclaiming Section 34.
Describing the 19-page document as well-reasoned and a well-written judgment, AG Al-Rawi also explained what the ruling means for the country and businessmen Ishwal Galbaransing, Amir Idu, and maritime life.
This means that the Administration of Justice Indictable Proceedings Act 2011 is the law. The repeal of Section 34 stands, and the proceedings before the magistrate in Piarco 1 and Piarco 2 can be concluded.
But the government, he says, still has its work cut out. According to Al-Rawi, there are now 3 pieces of legislation dealing with preliminary inquiries: the Administration of Justice Amendment Bill 2012, the Preliminary Inquiries Bill 2011, and the Indictable Offences Committal Proceeding Bill of 2014.
It is therefore now for the government, having had the benefit of this decision, to now clarify which route for preliminary inquiries is going to be selected as the preferred route.
Now, we may never get an answer as to why Section 34 was proclaimed. But what we do know is that Section 34 is no more. I'm Maria Rambly reporting for CNC3.
Martin George, the 3 pieces of legislation that the Attorney General outlined in terms of guidance for preliminary inquiries, of those 3, which do you think might be the best option?
Well, the thing is, I would imagine that it's something that the Parliament would have to debate. We'd have to see all the implications of each particular aspect of it. Clearly, the idea of paper committals is an idea that I think really is what saves time and it expedites matters. But of course, you also have to bear in mind that even with the paper committals, remember, you still also have cross-examination, which then can take up time. And, so the point is, you still have to look at the ways in which the system itself is clogged. You look at the magistrate's court, you look at the number of cases each day on a magistrate's list. If you are coming to court as a magistrate and you have 150 or 200 cases on your list, all you can really do practically is just go through and adjourn. You cannot sit on 200 trials in a day. So just for starters, maybe they need to look at introducing some kind of case management system in the magistrate's court whereby you have fixed appointments. So instead of everybody coming for 9 o'clock, which is really a phenomenal waste of time because you have so many police officers, hundreds of police officers who just sit around the court whole day waiting for the matter to call because you tell everybody to get there for 9. You cannot deal with everybody's matter at 9 o'clock. So therefore, we need to have a system whereby you maybe say, well, look, this matter will be 9:15, this one will be 9:30, and you make it clear to the public and to the attorneys that, look, you be there on time for your matter, otherwise it will be dealt with in your absence, one way or the other. You see, but to have everybody lumped up there, jostling for parking, it is just chaotic, and it doesn't work. We need to have a much more structured approach to dealing with these matters.
And just going back to the point that he made about the fact that the current Raleigh administration, then opposition, feels vindicated, and he was careful to enunciate the cabinet took the decision with regard to Section 34. It wasn't the entire parliament. Even though both houses of parliament would have voted on the legislation, passed it, both houses of the parliament did not say, well, let's proclaim Section 34 right away, as opposed to anything else.
He's going on the technicality of saying, well, look, the proclamation was a function of the cabinet, and he's quite correct in saying so. But the point is, when the bill was laid and when the legislation was being discussed and debated in the parliament, both sides of the house had opportunities to look at it objectively and possibly see the flaws and pitfalls. So I don't think there's any exoneration in that regard. Both sides of the house had the opportunity to look at it then. So I understand and I accept and I agree with him in terms of the proclamation aspect of it. But even before it reached to that, I don't think, if you check the records of Hansard, that there was any objection voiced to say, look, hey, this thing has dangerous implications because of A, B, C, so therefore it ought not to be passed. It ought not to be voted as a yay.
Let's travel back in time, back then, Martin George, as you make that point, and let's travel back in time and try to remember what it was like back then. Neither side of the house could have envisioned that anyone would be taking advantage of Section 34 that quickly, and specifically the individuals who would have filed their appeals. No one could have envisaged that would have been the case. As a matter of fact, when they were haggling over the legislation, that wasn't even, these people weren't even in their minds at all that this may have provided a loophole for them. They were just focusing on the fact that, okay, we're going to deal with this really abysmal situation with having people on remand for 10 years before they could get a preliminary inquiry stage. Yeah?
I can't answer because you seem to know what was operating in the minds of the parliamentarians.
I'm just going by what people would have said back then, that it never even occurred to them, that they weren't even thinking about the Piarco 1 and Piarco 2 scenarios being impacted by the proclamation of Section 34.
Well, if they weren't, then clearly the attorneys for the persons who filed the matters very quickly, they were certainly thinking of it. So, somebody was thinking of it. That's all I'll say.
So even though, Mr. George, locally the cases continue, I suppose in the minds of most members of the population, the word extradition would arise.
Well, no. The thing is, remember, the judgment of Justice Ronnie Boodoo Singh made it clear
should be tried locally.
Right.
Yes.
As far as he saw it, they ought to be tried locally.
Yes.
So, and that matter was never appealed by the state. So therefore, that decision stands. That decision stands. Now, and let's just look at that as a comparison. Remember, there were several other persons who were implicated in those matters, who were charged in the USA.
Yes,
They were tried. Some pleaded guilty. They've served their sentences.
And have been released.
And have been released.
Yes, indeed.
And we cannot even complete the preliminary inquiry for the matters that all originated here. It's just amazing when you consider the way our justice system has not functioned. It's actually been dysfunctional in this matter. This is a classic example of the dysfunction in the system.
So even though we praise the Privy Council and so on, isn't it about time that regional jurisprudence be given the opportunity to make history as the Privy Council has done over the hundreds of years it has been there?
Well, the point is, it's not just a question of time to say, well, it's time that, you replace the Privy Council. The point is, we do have more than enough competent local jurists and Caribbean jurists who can deliver the most brilliant and reasoned arguments. The question, as I said, is us ensuring that we do so in a manner where the court gets that level of respect that the Privy Council has. So maybe we might have to look and maybe think of creative ways, and maybe I don't know. I mean,
we can't get that respect until we invest them, and everybody comes on board in the Caribbean that we're going to have the CCJ as our final court of appeal.
Well, it's not even just coming on board, because you could come on board and say that, yes, we're going to accept it. I mean, just look at CARICOM. We've all come on board and said, yes, we accept CARICOM. But, I mean, who really gives CARICOM that respect when you look at the dysfunctional manner in which they've operated over the years? Look at, for instance, a regional body, say, for instance, the West Indies Cricket Board. We all accept that, yes, they're in charge of cricket, but, I mean, what are they doing? So the point is, we may agree that, yes, we want this, but beyond that, we need to see the functioning in a manner that rises above all partisanship, all insularity, all xenophobia. So therefore, you would always get that respect. And one thing you have with the distance of the Privy Council is that persons always consider them to be above the fray and above the pettiness of localized politics.
Mr. George, you made mention earlier about you're unable to comprehend why certain things were done. In regards to amendments, legislation, bills, acts, etc., can you clear up for us, and for me in particular and others, I'm sure, the thin line that exists with parliamentary interference into the independence of the judiciary?
Well, the thing is, in terms of this judgment, I will start there. The Privy Council made it clear that they did not see this judgment as an interference by Parliament with the powers of the judiciary, because what they said is that the Parliament was simply restoring the status quo to what it was before. So they didn't see it as any incursion on the independence of the judiciary. Of course, the effect of the repeal is that those matters which were filed could no longer proceed. But they did not see it as an attempt to curb or fetter the powers of the judiciary. And I think with respect in Trinidad and Tobago, by and large, we've seen the separation of powers work in the sense that there is always that respect for the role of the judiciary, the role of, the legislature as separate and distinct.
Looking at the role of the DPP here, Mr. George, the Privy Council, even though they were all unanimous in their judgment and so on, there seemed to be a slightly grey area as to the interference, quote unquote, of the DPP in the procedure.
Well, the way I see it, they admitted that he was in a difficult position in that he recognized that, look, there was a greater risk which maybe the politicians had not been alerted to. So he felt that he had to do something. I think the only criticism, if you would call it that, would be maybe the exuberance with which he pursued the course of action to try and, ensure that, something was done about it. But they were still always careful to see that he did not cross the line of, becoming a persecutor, and that he did not cross any threshold in terms of his role and function of DPP.
Now, moving forward, Mr. George, with the Piaco 1, Piaco 2 cases, can, as an attorney, the defending attorney, make any submission as to pre-trial publicity? In relation to the defendant, yes.
Right. Remember, I think we had touched on this when it came up with the Jack Warner issue. Now, the question of pretrial publicity is something that has already been raised by, I think, some of these defendants in the same Piaco matter. And the courts have consistently indicated that, look, first of all, when you're talking pretrial publicity, it has to be something that affects the mind of the decision maker. In this case, you have the magistrate who is sitting, so it has to be something that affects her mind to show that, look, this pre-trial publicity, if you want to call it that, is going to make her decide one way or the other. That's a very high threshold, evidentially, for you to be able to cross. And unless there are clear and demonstrable elements of evidence to show that, no court is going to uphold just a bald and, bland allegation of pretrial publicity. You see, I think the public generally misunderstands what that means. They think that publicity of a matter prior to its conclusion or while it's going on is always pretrial publicity that is actionable. It's not. It's publicity, yes, but the only time it becomes actionable is if you can show that it has occurred in such a way as to affect the minds of the decision makers. Now, at the High Court level, at a criminal trial where you are before a jury, you will now have to show that it affects the minds of the jury members. Yeah. So that's why generally in high-profile matters, they tend to sequester the juries and have them, live in at a hotel or whatever to try to insulate them as much as is humanly possible. But of course, with all the technology that's available, of course, people still have access to information. But of course, the judges always try to warn them not to let outside comments or statements influence their decision or the discharge of their sworn duty as a jury member.
As you make that point about social media impacting people's opinions and judgments on issues, we're going to have a situation where only the information that is provided in the court is what the jurors themselves, that's basically all they have to consider, and they can't allow anything else outside of that to influence whatever final decision they make.
Well, they're not supposed to. They're not supposed to. But, the point is, we know that there are situations where people do get affected by these things and they make decisions based on it.
It's almost impossible.
Sorry?
It's almost impossible because are you going to tell the jurors, do not watch the 7 o'clock news? Do not work with their computers. Do not work with their smartphones.
It's really difficult to avoid it. So that's why the judges would normally routinely repeat the warnings to the jury members. So in other words, they are aware that, look, they may hear things, they may see things, but notwithstanding that, they ask them to please disregard those things and focus on what comes out in evidence before the court.
In the High Court, could a judge take into account comments from the counsel for the people in a particular case? That a lawyer may say, Your Honor, I would not like this Mr. George to be a juror because so and so and so and so. What goes through the mind of the presiding judge as to whom he accepts to sit as the final panel for a jury.
No, remember, okay, when you are empaneling the jury, you do have the right to object to certain jury members. You can challenge, and the point is, in some cases, you don't need to give a reason. So you can just make a challenge and say, look, challenge, and that person has to step down.
They have to step down.
Yes.
Mm-hmm. Because if you allow them to stay there, then the case can be made that, whatever outcome, if it's against you, you can say it was prejudiced by this individual.
That's right.
So that's why they have to leave. Martin George, any other bits of information you want to share with us with regard to the possible outcomes of this particular ruling and judgment?
Well, the thing is, I think that what we have to do is look to move forward in terms of the preliminary inquiry and see if we can wrap that up as quickly as possible, because it really remains as an indictment against our judicial process and our justice system that this preliminary inquiry is going on for more than 10 years and cannot be concluded. We don't even know what is going to be the result after. In other words, the magistrate may discharge all the accused, or she may decide, well, look, yes, I find a case has been made out that, look, you can go up to the High Court to stand the trial. And then, of course, that's a whole other long process, because even that decision can be challenged. So the point is, let's try and move forward as quickly as possible, because it's not fair to the accused, it's not fair to the country, it's certainly not fair to the magistrate for this matter to be going on so long. So I think for all of us, we need to, we're all waiting to exhale. And I think the sooner we're able to do that, the better.
Apart from that critical next step, another critical next step would be for the Parliament to make a decision in terms of the method of preliminary inquiry that would become, the prescribed method.
Yes, that's right. Yes. So, that's a legislative change. So we hope that both sides of the House can agree on a sensible way forward in that regard.
Could another critical next step be the strengthening of the office of the DPP, do you think?
Well, remember, I've said repeatedly that there is a need for a whole lot more officers in the DPP's department, because I think we need to remove police prosecutors from all the magistrates' courts throughout Trinidad and Tobago and have only trained attorneys from the DPP's department. That would help to speed up and expedite things tremendously in terms of the prosecution of matters.
Okay. Martin George, thank you for giving us so much of your time this morning and for painstakingly explaining every step of the way the implications of this judgment by the Privy Council on the Section 34 matter.
Okay, thanks a whole lot.
Always a pleasure. I feel like I've been in the law class every time I chat with you. Thank you, sir.
It's always a pleasure. Have a great day. Thank you. Okay.
Sky 99.5 FM.